In this week's episode of the Crushing Debt Podcast, Usury Laws.
Welcome to the Crushing Debt Podcast with your host, Florida attorney Sean Yesner, where our goal is to help you get rid of the financial bullies in your life.
So welcome back to the Crushing Debt Podcast. My name is Sean Yesner, and the Crushing Debt Podcast is brought to you by Yesner Law, which created the scenario that created the podcast episode that I wanted to talk about today. So most of you know that I do a lot of foreclosure defense work in my practice, but I also do some plaintiff foreclosure work. Now, I don't represent banks, so you'll never see me representing Bank of America or Regions or Wells Fargo or any of those kinds of big banks. I did that in my prior career. That's how I learned everything that I know about foreclosure law, was by representing lenders in foreclosure. But every once in a while, I'll get a private investor who holds a first mortgage or a second mortgage or a lien against a piece of property, and when they don't get paid, that hurts them as well. And so I do represent people who hold private mortgages, second mortgages, first mortgages, whatever. And that's how this case arose. I represented somebody who owned a second mortgage on a piece of property. The second mortgage ballooned, and the creditor was never paid. The mortgage holder, the individual, was never paid. And so he asked me to do a foreclosure lawsuit to get him his money, or if not his money, the property. And so based on the failure to pay the balloon, I filed the foreclosure lawsuit. Now, a couple of provisions that we needed to talk about here within this case. So it was a second mortgage. It was a balloon mortgage. So that means the borrower was to make a certain number of payments, and then the final payment was the payoff of the entire thing. So the final payment, I think, was somewhere north of $80,000 in this particular case. The note collected interest at a certain rate, but the note said that if any installment wasn't made, it would jump to a default interest rate of 18%. So whatever the interest rate was, 5 or 6%, I don't remember, it jumped up to 18% when there was a default. The note also said that if the borrower did not make an installment when it was due, the borrower would be charged a 5% late charge. So $80,000 plus or minus balloon payment, a late charge of 5%, and default interest of 18%. And so we file the lawsuit. The defense attorney makes some defenses. We finally get it positioned to a place where we can go to trial. On the eve of trial, I get a request from the opposing counsel to provide a payoff letter. And so I sent a payoff letter. Now, the payoff letter contained a few things. It contained the balloon payment of $80-something thousand that was due. It contained about a $4,000 penalty late charge on the balloon payment that was never paid. Since it was never paid, it was late, and we charged a 5% late charge, and it included the 18% default interest, as well as some other stuff like attorney's fees and costs and those types of things. Well, I got a call from the opposing attorney saying, hey, you may have violated usury laws. So for those of you who don't know, usury laws basically cap the rate of interest that can be charged in a transaction. And in Florida, it's 18%. So in a mortgage situation like this, we could not charge more than 18%. And so opposing counsel's argument was this: by charging a 5% late charge on a balloon payment, we were really charging a finance charge, not a late charge. And when you add a 5% finance charge to an 18% default interest rate, you actually get a 23% rate of interest, which is in violation of Florida's usury laws. Now, I disagree with him for a couple of reasons. First of all, you can't just add the 5% late charge and the 18% interest charge, even if you feel that the 5% is really a finance charge or a penalty or interest. You can't really add them up. You've got to spread that 5% late charge over the entire term of the loan. But still, the fact that we were charging default interest rate of 18%, if the opposing attorney was correct in his analysis, even 0.1% would have bumped the entire interest rate above 18%, and it would have been usury. But I disagreed with him for another reason. And so I researched the laws, and here's what I found out. Florida has a statute. It is statute 687.03, for those of you that want the statutory reference. And subsection 2C of that statute section says, that if the contract provides, the creditor can charge a delinquency charge on each installment which is in default for a period of not less than 10 days in an amount not in excess of 5% of such installment. However, only one such delinquency charge may be collected on any installment, regardless of the period during which it remains in default. A delinquency charge imposed pursuant to this paragraph shall not be deemed interest or a finance charge made incident to or as a condition to the grant of the loan or other extension of credit, and shall not be included in determining the limit on such charges as provided in this section. So, a couple of things in that statutory language. First is that we can charge a late charge of 5% on any installment, as long as the payment is in default, as long as we have not received the payment for at least 10 days or more. So in this case, the 5% late charge was accurate, as long as it is charged on an installment. So now we get to what is the definition of an installment. And if this is an installment, if the balloon payment is an installment, then the statute specifically says it's a late charge and therefore does not fall under usury laws. So I then found a case out of the First District Court of Appeal. The First District Court of Appeal in Florida actually ruled against us. The First District Court of Appeal, in a case called Oryx Capital Markets LLC versus Park Avenue Associates Limited, the First District Court of Appeal says the last payment is the last payment. And this was a decision that the First District issued in August of 2004. So in August of 2004, the First District Court of Appeals in Florida said the last payment is the last payment. The last payment is not an installment. And so if the First District is right, then charging 5% on the balloon payment theoretically could have been in violation of usury. But the year later, in 2004, the Fourth District Court of Appeal, in a case called Schroeder versus Mansari, in Schroeder versus Mansari, the Fourth District Court of Appeal said that's crazy talk. The last payment, the balloon payment, is an installment payment. And since the last payment is an installment payment, then it is not usury to charge the 5% because the statute says a late charge charged on an installment is not usury. So we have a conflict between the First District and the Fourth District, issued a year apart. Typically in a situation like that, the Supreme Court will take over and the Supreme Court will issue its ruling. Well, that hasn't happened yet here in the state of Florida. Nobody has appealed that decision all the way up to the Supreme Court to say, hey, Supreme Court, we've got two districts here that are in dispute. Please reconcile. Tell us which one's right, tell us which one's wrong, or reconcile them. That hasn't happened yet. So the Supreme Court of Florida hasn't weighed in on this issue. The other thing that was a little bit concerning in my case that I had specifically, I'm here in Tampa. Tampa is within the Second District Court of Appeals. And so the Second District Court of Appeals has not addressed this issue either. So in order to argue this issue to the judge, I have to convince the judge that the Fourth Circuit that issued their opinion in 2005 is right, and the First District that issued their opinion in 2004 is wrong. And opposing counsel has to argue the opposite because the Second District Court of Appeal has not yet weighed in on this issue either, and so there is no direct binding authority, and the two districts that we would look at for a recommendation are opposite of each other. So luckily, or unfortunately, I don't have a definite answer for you on whether this issue is usury or not. I mean, I have my opinion that it's not, but I may be blinded in that I am representing my client. The resolution here was we ended up settling with the defendant to get an extended sale date. So we agreed that the foreclosure sale would be some extended period of time. I think it was 90 days from the date of the hearing, and the defendant in exchange agreed that it was actually a late charge that we could charge. And so if he's able to sell his house, he'll pay off that late charge, but now he's got 90 days from the foreclosure sale to do it. So that's all for this week's episode, but what I really want to know is, what do you all think? Do you all agree with the First Circuit Court of Appeals that the last payment is not an installment? It's the last payment. It's the balloon. And if it's not an installment, there can't be a late charge charged on it. Or Do you agree with the Fourth Circuit that says the last payment, the balloon payment, is an installment? It just happens to be the last installment, and it happens to be a huge installment, but it is an installment. Which one do you agree with? Do you agree with the First District? Do you agree with the Fourth District? I'd really like to know. Let me know either on social media. Shoot me a message on social media. Shoot me a message by email, sean@yesnerlaw.com. I really appreciate your listening to every episode, and we will be back in next week's episode of the Crushing Debt podcast.
If you have questions that you think would make a great topic for a future episode, please email Sean or connect with us on social media. Sean Yesner and Yesner Law, PL, are Florida licensed attorneys. The information contained in this week's episode is not a substitute for legal advice. Your situation may differ, especially if you are located somewhere other than the state of Florida. If you have questions, please contact our office or contact a local attorney. Thank you for listening to this week's episode of the Crushing Debt Podcast.